There has been a lot of confusion spreading online recently claiming that the U.S. Supreme Court has passed a sweeping decision that completely changes gun laws across all 50 states. Some posts and videos suggest that permit systems, waiting periods, training requirements, and even entire categories of gun restrictions have been instantly struck down nationwide. The language sounds dramatic, breaking news style, and very final, but the reality is quite different. As of now, there is no single Supreme Court decision that has erased all gun laws or created a uniform system where states can no longer regulate firearms. What is actually happening is more gradual, more legal, and much more complex. Instead of one ruling changing everything overnight, the Supreme Court has been building a new framework for how courts must evaluate gun laws under the Second Amendment. That framework is slowly reshaping the way cases are decided across the country. The most important turning point in modern gun law came from a landmark case known as New York State Rifle and Pistol Association v. Bruin. In that decision, the Supreme Court changed the standard used to judge whether gun laws are constitutional. Before this case, courts often used a balancing approach. They would weigh the government's interest in public safety against an individual's right to carry firearms. If the law seemed reasonable enough, it could be upheld. But Bruin changed that approach completely. The court ruled that this kind of balancing test is not appropriate for constitutional rights like the Second Amendment. Instead, judges must now look at whether a gun regulation is consistent with the text of the Constitution and whether it has historical support from the time the Second Amendment was written. In simple terms, if a modern gun law cannot be reasonably justified by historical tradition, it becomes much harder to defend in court. This shift is extremely important, but it does not automatically cancel existing gun laws. It does not erase permit systems or instantly remove waiting periods. Instead, it creates a stricter legal test that courts must use when evaluating challenges to those laws. Since this decision, lower courts across the United States have been applying this new standard to different types of gun regulations. Some laws have been struck down, especially those that involve strict discretionary systems or requirements that judges find lack historical backing. Other laws have been upheld when courts determine there is enough historical similarity or justification. This has created a patchwork of decisions rather than a single nationwide outcome. For example, concealed carry laws have been heavily affected by this new standard. In many states, older systems required applicants to prove a special need or good cause before they could carry a firearm in public. Under the new interpretation, courts have found that requiring citizens to demonstrate a special reason for exercising a constitutional right is more difficult to justify. As a result, some of these systems have been struck down or modified. However, that does not mean all permit systems are gone. Many states still require background checks, licensing procedures, and other forms of regulation. What has changed is the level of scrutiny applied to those laws, not their automatic removal. Another area often discussed online is waiting periods for firearm purchases. Some states require buyers to wait several days after passing a background check before taking possession of a firearm. Critics of these laws argue that once a background check is complete, additional waiting serves little purpose. Supporters argue that waiting periods can reduce impulsive acts of violence. So far, courts have not issued a blanket ruling eliminating all waiting periods. Instead, they examine each law individually under the historical test, and outcomes vary. Training requirements are another commonly misunderstood area. Some jurisdictions require firearm safety training before issuing permits. While training itself is widely supported as a safety measure, the legal question is whether the government can require it as a strict prerequisite to exercising a constitutional right. Courts have not created a nationwide rule banning training requirements. Instead, they evaluate whether specific requirements are reasonable and historically grounded. One of the biggest misconceptions online is the idea that all discretionary gun laws have been eliminated. In some states, local authorities previously had broad discretion to approve or deny firearm permits based on subjective judgment. Under recent Supreme Court guidance, such discretionary systems are under greater legal pressure because constitutional rights generally require objective standards. However, this does not mean every form of discretion is gone everywhere. It means courts are more likely to strike down systems that are too vague or arbitrary. It is also important to understand that gun laws in the United States are still primarily made at the state level. Even after major Supreme Court decisions, there is no single national gun law system that overrides all state regulations. Instead, federal courts evaluate whether state laws violate the Constitution. If a law is found unconstitutional in a specific case, it may be struck down or limited in that jurisdiction. But other laws remain in place unless challenged and decided by courts. Because of this, different states are experiencing different outcomes. Some states with more restrictive gun laws are seeing more legal challenges. Others with more permissive systems are seeing fewer changes. This is why the legal landscape looks uneven across the country. It is not because one ruling changed everything, but because multiple cases are still working their way through the court system. It is also important to separate legal reality from viral content. Social media often simplifies or exaggerates complex court decisions to make them sound more dramatic. Headlines claiming that all gun laws have been struck down or that the Supreme Court issued a sweeping nationwide reversal are not accurate. They take real legal developments and stretch them far beyond what actually happened. What is real is that the Supreme Court has strengthened the standard used to evaluate gun laws. This makes it harder for certain types of restrictions to survive legal challenges. It also means future laws must be more carefully designed to fit within constitutional limits. But it does not mean that gun regulation has disappeared or that states can no longer enforce laws related to firearms. Looking forward, the impact of these decisions will continue to unfold in lower courts. Many cases are still being filed and reviewed. Some laws will be upheld, others will be struck down, and many will be modified. Over time, this will shape the future of gun regulation in a gradual way rather than a sudden nationwide shift. For gun owners and citizens, the most important thing to understand is that the legal system is in a period of transition. Rights under the Second Amendment are being interpreted more strictly by courts, but that interpretation still allows for regulation. The balance between individual rights and public safety continues to be debated in courtrooms, legislatures, and legal scholarship. In simple terms, nothing has been instantly erased. There is no single ruling that removed all gun control across America. Instead, there is a continuing constitutional shift that is making courts more demanding when reviewing gun laws. States must now justify their regulations more carefully, and judges are applying a stricter historical test when deciding cases. This means the future of gun law will not be defined by one dramatic ruling, but by many smaller decisions over time. Each case adds another piece to the legal framework. And as those cases continue, the interpretation of the Second Amendment will keep evolving. So the real story is not about a sudden nationwide change. It is about an ongoing legal process that is reshaping how gun laws are judged, challenged, and enforced across the United States.